Hey everyone, it's Rob Ryder on Sunday, November 17th, 2013. And I don't really have a plan of action yet what to do with this information. I just got so much of it squeezing out of my fingers, it's like, okay, I got to put some of it onto a video. So that's what I'm doing today. And I hope that with it, those of you that are already in a position where you have a court case going on with a foreclosure or so forth, maybe you'll go ask the questions that need to be asked. See if we can make something happen with this. But what we're going to be talking about are confessed judgments, implied trust, and foreclosure law. And I'm using Illinois as an example. And so, of course, I'm Rob Ryder. My email address is courtofrecord@aol.com. My phone number 616-712-6179. If you can, please donate on the PayPal account to ashleyritlewski@gmail.com or snail mail to myself at 10955 14 Mile Road, Rockford, Michigan 49341. Okay, and so where do you start? Well, let's start with a few definitions. Implied, referring to circumstances, conduct, or statements of one or both parties which substitute for explicit language to prove authority to act. Warranty, promise, trust, agreement, consent, or easement, among other things. These circumstances imply something rather than spell it out, right? So, conduct or statements of one or both parties. So one party could say something, and if you don't know what they said because you don't understand their language, it still could be an implied contract, an implied trust, an implied agreement, implied consent. So like implied consent. When surrounding circumstances exist that would lead a reasonable person to believe that this consent had been given, although no direct express or explicit words of agreement had been uttered. An example, a contract based on the fact that one person has been doing a particular thing and the other person expects him or her to continue. And here's another one. B, the defense in a date rape case in which there is a claim of assumed consent due to the absence of protest or a belief that no really meant yes, maybe, or later. There you go, right? That's how bad it can be. Implied consent. No means yes to some people, and so they're going to believe they have implied consent. Well, it may not be date rape, but it's certainly financial rape that's happening to you in a foreclosure, because no means yes to some people. An implied in fact contract is a contract agreed by nonverbal conduct rather than by explicit words. Don't even need to use any words and you get into an implied in fact contract. All right, now we're talking about the secret signs. As defined by the United States Supreme Court, it is an agreement implied in fact as founded upon a meeting of minds. Remember that, got to have a meeting of minds, which although not embodied in an express contract is inferred as a fact from the conduct of the parties, showing that in light of the surrounding circumstances, their tacit understanding. Do you understand? All right, we're gonna file this for you. Okay. Well, when somebody files something for you, they just deposited it and they just became the trustee of it. Right now they have a legal title to it. It's in their drawer. Just because you said, yeah, go ahead and file it for me. Although the parties may not have exchanged words of agreement, their actions may indicate that an agreement existed anyways. So obviously we have some presumptions that need to be rebutted. Generally, an implied contract has the same legal force as an express contract. However, it may be more difficult to prove, to have proof, the existence and terms of the implied contract should a dispute arise. So we need to create the controversy. In some jurisdictions, contracts involving real estate may not be created on implied in fact basis. That's good to know, because that's exactly what they're doing to us. Unilateral contracts are often a subject matter of these types of contracts where acceptance is being made by beginning a specific task. Okay, so what's a unilateral contract? That's when only one person signs. What's the acceptance of the other side? Well, when they begin a specific task. That's what they're saying. Okay? Now, these have nothing to do with that. This is just a few definitions that are going to be important in today's conversation. Extinguishment of a debt. Debts may be extinguished by a creditor accepting a higher security. Let's stop right there and think about that. Debts may be extinguished by the creditor accepting a higher security. What do they do with your promissory note in a foreclosure? They flip it over in the back, endorse it, pay to the order of, and they take a higher security. Right now they're going to take bank notes instead of your promissory note. Again, the promissory note isn't a promissory note if its mature date is more than 9 months out. It's just a note. It's a form of security. And when they take that and turn it into bank notes, they took a higher form of security. Your debt has just been extinguished. I think you ought to tell them that. Let's find out how. A debt evidenced by a note may be extinguished by surrender of the note. Okay, who's got the original note? When you give it to whomever, when you filled it out, and they took it and endorsed it, they gave it to somebody else. They surrendered the note. It was surrendered to somebody else. So, again, the note's been surrendered. There is no debt. And this would be important too. Trust. Probate courts have exclusive legal and equitable jurisdiction over proceedings concerning the validity, internal affair, and settlements of trust. Because we're going to be looking at an implied trust. It ain't actually written as a trust. It's just going to be implied that it is. So we're concerned about the validity. Now, this probate court we're talking about is not the probate court, in my opinion, that we see when you walk in. It's not that probate court. The probate court, this probate court, would actually be lowercase probate court, except it starts the sentence, is the constitutional probate court. And it has certain, it started as the ecclesiastic court way back when. And the last video I did, the one just before this, we went through all this stuff, right? So if you just do a search by upload date, use trusts and something else, I think it was called, tell you all about it. So, okay, so where is all this leading? Well, let's start with what? I guess we start here. This is the Illinois mortgage foreclosure law. Okay, and the court has full power to enforce any order entered pursuant to this article by contempt process or by such other order as may be appropriate. Right, so the court has authority. The authority of the court continues during the entire pendency of the foreclosure and until disposition of all matters arising out of the foreclosure. Wrongful inducement of abandonment. Any person who willfully misrepresents to the court any fact resulting in and a finding of abandonment of mortgage real estate in connection with these other subsections, yada yada yada, right, is guilty of a misdemeanor. So if they, because at some point in a foreclosure, the idea is get you out of the house by whatever means necessary. Sheriff puts his paperwork on it. He's now the proprietor of the property. The game continues, right? Whatever they need to do to get you out of the house to say it's been abandoned. And they're just going to say it's been abandoned anyways. Because you don't answer the mail. Hey, we keep sending the mail. No one answers. I guess there's nobody there. Of course, they're not actually sending the mail to you. It's going to lost mail. May means maybe. A lot of times may means must, but here it means may means maybe. Shall means must. Mandatory. Exclusive procedure. From or after the effective date of this, the following shall be foreclosed in a foreclosure pursuant to this article: any real estate installment contract, any collateral assignment made with respect to a land trust, as to which security agreement or other writing creating the collateral permits the real estate which the subject to the land trust to be sold to satisfy the obligation. What I didn't do, gosh darn it. Okay, bear with me. Hopefully I can find it real quick. This is really what got me off on this in the first place. I started looking at all this crap. Where was... this was from Rose friend in Illinois, Brown, who's in a foreclosure. And so this is the civil cover sheet that the foreclosing people filled out. And it says it's a mortgage foreclosure, owner occupied, single family home or condominium. They are saying he's the owner. Look at that. But basically, plaintiff files complaint to foreclose mortgage, trust deed, other conveyances in the nature of a mortgage or an after called mortgage. Okay. Plaintiff files this complaint to foreclose the mortgage, trust deed, other conveyances in the nature of a mortgage. Remember that, in the nature of a mortgage. Hereinafter called mortgage. Hereinafter described pursuant to, right? So they're doing it pursuant to this set of laws we're looking at right now. And so one of the things is, we get down to the part that here we go. Instruments deemed a mortgage. For the purpose of proceedings under this article, any instrument described in 2 or 3 of subsection A is the 1106 and B and C of 1106 is foreclosed under this article shall be deemed a mortgage. Okay, so what are those things? Let's go to 1106. Here's 1106. Okay, one of them is a real estate installment contract. Now you can easily look that up if you just go and Google real estate installment contract. It'll show you what one looks like. And I don't believe that's what it is. Okay, so that's a mortgage, and so is any collateral assignment of beneficial interest made on or after, which is made with respect to a land trust. Right, so the deed of trust itself, or the mortgage, this piece of paper by itself, isn't a mortgage unless it's in conjunction with a land trust. Because what this thing really is a collateral assignment. You're going to assign some collateral over to the bank or to the lender or to the trustee for the lender until you've paid back the debt. But where's the land trust? How do we get involved in a land trust? That's the question. Are we involved in a land trust? Where was the land trust? Which was created contemporaneously with the collateral assignment of beneficial interest. So basically that means it was made about the same time that you made this this mortgage, the collateral assignment. You got involved in a land trust, which is made pursuant to a requirement of the holder of the obligation to secure the payment of money or performance of obligations, and as to which the security agreement or other writing creating the collateral assignment. Right, so security agreement, well, this is a security instrument. And that is evidenced by what it says right here. By signing below, agrees to perform the covenants contained in this security instrument. Is it an agreement? Well, if it's a unilateral contract, it's an agreement. That's what they said. A unilateral contract, by them starting something makes it an agreement in their mind. So, but basically, what this is getting down to is, by this foreclosure law, it can be used for 2 things. It can be used if there's a real estate installment contract, or if there is a collateral assignment that is made with respect to a land trust. It's the only 2 things that they can use this particular foreclosure law for. Okay, so now if a mortgage lien is being foreclosed under this article and one or more non-mortgage liens or encumbrances is being foreclosed or enforced in the same proceeding, then regardless of the respective priorities of the various liens or encumbrances, the procedures and all other provisions of this article shall govern such proceedings, and any inconsistent statutory provision shall not be applicable. Okay, and we don't have a mechanics lien, although it could be, I believe it could be enforced under this, although they have their own thing for mechanics liens. Okay, so before we get into the facts, so the question is, where did the frickin' land trust come from, if there is such a thing? Well, let's take a look here. Okay, first of all, we have a thing called a warranty deed, right? A deed is a written document which transfers title, ownership, or an interest in real property to another person. The deed must describe the real property, name the party transferring the property, the grantor, the party receiving the property, the grantee, and be signed and notarized by the grantor. To complete the transfer conveyance, the deed must be recorded in the office of the county recorder or the recorder of deeds. Now this is very interesting. They specifically say office of the county recorder. Now I believe this came out of Bouvier's, right? Or the recorder of deeds. Well, in Michigan we don't have a recorder of deeds, we have a register of deeds. But I'm sure they do mean a recorder of deeds, and that would probably be through the county clerk. And I don't have all this information to share with you, but it was things that came up in the last couple of weeks. First of all, in Illinois, they have a recorder's office. But if you look in the statutes, it says the county clerk is ex officio the county recorder. And this says you're supposed to record it with the county recorder. So where do you record it? Do you record it in the recorder's office or with the county recorder? I guess you should do it with the county recorder. Do you record it with the register of deeds or the recorder of deeds? Well, this says the recorder of deeds. It didn't say register of deeds, so where's the frickin' recorder of deeds? And when a deed is writing under seal delivered makes it a deed. And there's all sorts of that stuff in the county clerk's office. Forgetting the fact that it doesn't have to be in the register of deeds office in Michigan. You should be able to record it with the county clerk. Now they're not going to want to do it, but I'm just saying. Now what's a trust? An equitable right, title, or interest in property, real or personal, distinct from legal ownership, or it is a personal obligation for paying, delivering, or performing anything where the person trusting has no real right or security, or by the act he confides altogether to the faithfulness of those entrusted. Okay, whatever all that means. Why did I bring this up? Because there's a thing called implied trust, or those which, without being expressed, are deducible from the nature of the transaction as matters of intent, or which are superinduced upon the transaction by operation of law as matters of equity, independently of the particular intention of the parties. The most common form of implied trust is where property or money is delivered by one person to another, to be by the later delivered to the third person. This implied trust greatly extends over the business and pursuits of men. Few examples are to be given. And here we go. When land is purchased by one man in the name of another, and the former pays the consideration money, the land will in general be held by the grantee in trust for the person who so paid the consideration money. When the land is purchased by one person in the name of another, and the former, right, the one man, pays the consideration money, look at your warranty deed and tell me who paid the frickin' $10. Well, this ain't the first time this has been brought up. I've been talking about it for 2 years now. Who paid the $10? For $10 in hand paid and other valuable consideration, but who paid the $10? Now, people who have asked attorneys about this say, oh, that's just the custom, the way they do it. That's fucking bullshit. Who paid the $10? Because that's the former pays the consideration money, and the land will, in general, be held by the grantee, you, in trust for the person former who paid the $10. They just made you the trustee of a trust. And they've given you legal title, but he's going to keep the beneficial title. And that's why when we go into court, they say you're going into a court of equity. Because they're trying to say we have legal title, they have equitable title. When a contract is made for the sale of land in equity, the vendor is immediately deemed a trustee to the vendee of the estate, and the vendee a trustee to the vendor of the purchase money. Right? So who paid the $10? Because the vendor is the grantor, and he just gave it to the grantee, the vendee, us now being made a trustee to the vendor of the purchase money, who gave the $10. They just created a land trust, implied land trust. Presumption respecting, this is Oregon law, presumption respecting deed from trustee of undisclosed beneficiary. If a deed of real estate has been made to a grantee in trust, or designating the grantee as a trustee, and no beneficiary is indicated or named in the deed thereafter executed by the grantee conveying the property is presumed to have been executed with full right and authority and conveys prima facie title to the property. See, you have legal title. They're saying you have legal title. You have the legal title. Somebody else got the beneficial title. The guy that paid the $10. And this is saying no beneficiary needs to be listed. In a tax sale, any delinquency shall have the force and effect of a sale to the county tax collector as grantee and trust for the county. If you're delinquent, the county tax collector just became the legal title holder to the property. He's the grantee and trust. The county ownership and trust of the affected property ripens into fee simple upon the county's complying with statutory provisions described herein. What do they got to do? Send written notice of the delinquency to the record owners and parties in interest of record. Well, guess what? They just became the owner of the property. They don't need to fucking tell you. By you being delinquent, they became the grantee and trust. They just claimed legal title of the property. That's the way it looks to me. So now they don't have to send you anything. Now they do send you stuff, but they're not sending you the fact that this is a $5 tax you didn't pay. They're talking about we're talking about the excise tax, the direct tax that the government is authorized to impose on you. That's what we're talking about. That tax. They're not telling you about that tax. They're hiding that tax. As expressed by a Supreme Court in some case, the rules of imposition of constructive tax is well established that although a conveyance of land is absolute in terms and on its face purports to convey a estate and fee, it may nevertheless be shown that the land are held by the grantee in trust. If you got a warranty deed and you're the grantee and somebody else paid the $10, you're just the grantee in trust holding the property for the guy that paid the $10 who now has the beneficial interest. In order, however, that the land so conveyed may be impressed with the trust must be created and its terms agreed upon by the parties to the instrument at the time of the execution, or the instrument must be executed pursuant of such previous agreement. So they're not coming to us and telling us they're doing this. It's based on a previous agreement. And I think this goes back to 1930 when they took all the land in the first place. Right? That chain has never been broken. It's the same $10. It's been $10 since they took all the titles. It's a previous agreement. And so they're saying, well, that's the way it was before. We're just doing it again. I guess you understood. We figured you knew what was going on. And so we need to go to the lowercase probate court to say, hey, is this trust valid? I was buying the property. I wasn't giving it to him, this guy, for $10. Let me give him his $10. If one buys land in the name of another and pays the consideration thereof, and the land will be held by the grantee in trust for the benefit of him who advances the purchase money, who paid the $10. This is in Florida. Every deed or conveyance of real estate there heretofore and hereafter made or executed in which the word trustee or as trustee are added to the name of the grantee, in which there no beneficiaries are named, the nature and purpose of the trust, if any, are set forth, and the trust is not identified by title or date, shall grant and is hereby declared to have granted fee simple estate with full power and authority to the grantee. Here's the point. They don't want to do that. That's why they don't say there's a trustee involved. That's why they don't identify why there's no beneficiaries named. Right? They don't want to give you fee simple. They just want to give you legal title, because fee simple would mean you had equitable and legal title, both the legal and beneficial interest. They want to keep the beneficial interest, give you the legal interest. You have the legal title, you have to pay the taxes. Okay, so that's kind of what's going on with that. A warranty deed, this is what a trust attorney says. So one thing we might do is go ask a trust attorney. Don't call them on the phone, set up a meeting. A warranty deed transfers ownership of the property. The grantee on the warranty deed is the owner. If the grantee of the warranty deed is the trustee of the trust, then the trust owns the property. Right? Ask a trust. Say, I believe this is an implied trust. I didn't pay the $10. Somebody paid $10, and according to Bouvier's implied trust, when land is purchased by one man in the name of another, and the former pays the consideration money, the land will in general be held by the grantee in trust for the person who so paid the consideration of the money. Why is that important? What's a land trust? What's it do? Here's some facts about a land trust. A land trust is a simple and inexpensive method of handling ownership of real estate. If it is an arrangement by which the recorded title to the real estate is held by the trustee, right? Where did they record the title? Register of deeds, wherever it is. Recorded in your name, you're the trustee. But all rights and conveniences of the ownership are exercised by the beneficial owner, whose interest is not disclosed. We don't know who he is. The beneficiary of the land trust changes his or her interest in the property from the real estate to personal property, ownership of the beneficial interest. Not burdened with the legal characteristics. Don't need to pay the tax. Beneficial interest is considered to be personal property. How does a land trust operate? Under a land trust agreement, the beneficiary retains complete control of the real estate in the same manner as if the recorded title were in his or her name. He or she may end the trust whenever desired and may add additional property to the trust at any time. At all times, the beneficiary deals with the property as though he or she were the record title owner. For, as a matter of fact, he or she is the owner. You're not the owner. Grantee's a trustee. You're not the owner. They're saying the owner is the person with the beneficial interest. It's not that we couldn't have some beneficial interest, but some of the beneficial interest is with this other beneficial owner who's unknown to us. When title real estate is held in a land trust, the interest of the beneficiary under the terms of the trust agreement is personal property. Privacy of ownership. Under a land trust, the identity of the real owner is never disclosed to the public. Go figure. You're never going to know who they are. Of course, certain governmental agencies, the probate court, and others following valid and authorized legal process, hey, I want to put a complaint in, can ask about the beneficial ownership. Protection of the owner. If the property is owned by two or more persons, yada, yada, yada. Succession ownership. It has been common practice to create joint tenancy in real estate, holding solely for the purpose of providing succession of ownership upon death without the expense or delay of probate proceedings. They really don't want this to go to probate because probate's going to look at this trust and say, hey, this trust is invalid. Under joint ownership, however, either of the joint tenants is given an immediate interest in the ownership and management of the property, and in many cases, handicaps the real owner. He cannot deal with the property without written consent of the joint owner, yada, yada, yada. Under land trust agreement, the party creating the trust can retain sole control over the property during his or her lifetime, with the desired succession and ownership becoming effective upon death without, under certain conditions, the expense of going to the probate proceedings. I think because the other person who lent the $10 is a corporation, which never dies. Right? It's a legal person, not a natural person. You create a land trust by signing a short trust agreement, like a warranty deed. Under the agreement, you, the owner, called the beneficiary, direct the corporate fiduciary to hold title for the estate for you. Now, this could be what started this whole thing way back in the 30s, right? With the trust company. A corporate fiduciary to hold title to the real estate for you. And actually, this is the proper way to do it. That's what we're reading, right? What we're talking about is an applied land trust. It really isn't a land trust. They didn't do these things. It's just implied that it's a land trust because somebody paid the $10 and you're the grantee. So the big thing's it keeps the beneficial owners secret. Title of the real estate is held in the name of the trustee, so you're holding the title to the real estate. An additional advantage of the land trust in case of multiple ownership is that one or more of the beneficiaries may exercise power or direction on behalf of all the beneficiaries, thereby facilitating management of the trust property. Right? If there's more than one beneficial owner and you don't know this, there's other people that can direct stuff to happen. And I think that's what's happening. The real estate owner is entitled to such privacy in a real estate transaction as the owner's stocks and bonds. Title to real estate need not be a matter of public record. Title is simply transferred to and from the trustee upon the written direction of the beneficiary. Interest of beneficiary in a land trust is personality. The real estate is protected from judgments of liens against the beneficiary. Once a real estate is placed in land trust, it is not necessary to sign a deed or execute a real estate contract to transfer the beneficial interest. A beneficiary may merely assign his entire interest or any part to whomever he so chooses, which is why I think that somehow we were a beneficiary in this. We were the trustee with beneficial interest also, and we gave ours away on the warranty or on the deed of trust, mortgage, deed of trust, whatever it's called. Sort of like collateral for financing. The beneficial interest in a land trust offers excellent security for a loan. They love to have it. Unless real estate is held in joint tenancy, it is usually subject to probate. However, when property is held in land trust, probate is not necessary to pass title to the owners. And, why is probate important? Because it's probate that can determine if the trust is valid. And I'm not going to go on the rest of this, but now we have the act may be cited as the Land Trust Beneficial Interest Disclosure Act. So how do we get the beneficial interest disclosed? And I haven't had a chance to go through all this yet, but that's not the idea for right now anyways. Right now it's just to point some things out. Like I said, that I don't know what to do them all yet, but it is what it is, so we do what we do. Now, let's go one step further. This was knowing what we know now, or have seen. This is the original summons for Roe and her husband's foreclosure. And right off the bat, well, besides it not having a file stamp, there's no amount claimed. Right? They're not summoned to appear. They're told you are hereby summoned and required to file an answer. But it didn't say summoned to appear. This one up here says you're summoned and required to appear. This one just says you need to file an answer. Process server, data service. Now look at, this is two different lines down here. You got a witness, and then you got the clerk of the court. There's no witness on this piece of paper, yet the clerk of the court signed it, or put their seal on it. And there's a little seal there, and I believe that to be the court seal. Alright, so 16th Judicial, let's get it real big. 16th Judicial Circuit, Kane County, Illinois. I guess that's a court seal. Okay. So, the reason I showed you all that was mainly for just a couple things here. Number one is, this is a foreclosure on property and they're not claiming any amount of money. Zero. I guess that would make it a small claim. Let's see where that leads us. Okay. Here we go. If you were to Google Illinois Supreme Court rules, I think is probably the best way to do it. You come up with a site, and one of them is Rule 289, which has to do with small claims, which is lower into what we're going to talk about. I wanted to put at the top so that we got it out of the way first. Service of process and proceedings to confirm a judgment by confession, or to collect a judgment for $10,000 or less. Right? So there's two things you can use this small claims court for. One is confirm a judgment by confession, and the other one is to collect a judgment less than $10,000. In proceedings to confirm a judgment by confession or to collect a judgment for money. Right? So first of all, it doesn't have to be for money at all. It's just you're trying to confirm a judgment by confession. Service would be by Rule 284. Court jurisdiction. Small Claims Court. Small Claims Court is under the jurisdiction of the Clerks of Courts Act, 705 ILCS paragraph 90, and Supreme Court Rule 282. Circuit Court, right? But the Circuit Court also has jurisdiction over small claims actions. So the interesting thing is, from the Attorney General website, it says Small Claims Court is under the jurisdiction of the Clerks of Courts Act, 705 ILCS para 90. It doesn't exist, or they're hiding it. You cannot find 705 ILCS para 90. You'll find the Clerk of Courts Act, but it's 705 ILCS like 112 or something like that. But where is this para 90? Right, so got to get with Roe and have her check with the Attorney General, find out, hey, where is this? Right, you put it, this is off your website, 705 ILCS para 90. Either it's an error or omission, fix it, or give me the damn paperwork. And so it says, small claims. For the purpose of application of these rules, a small claim is a civil action based on either a tort or contract for money, or for the collection of taxes. Go figure. Tort. What's a tort? Well, there's a couple of kinds of torts, but torts of this nature, which means without force, are to the absolute or relative rights of persons or personal property in possession or reversion, or to the real property, corporeal, incorporeal, in possession or reversion. In other words, it has to do with property. It doesn't have to do with money. And so torts are covered under small claims. You don't have to charge. You don't have to put any amount of money in. You ain't got to put no amount of money in, and there's none claimed. Okay. Commencement of actions. An action of a small claim may be commenced by paying to the clerk of the court the required filing fee and filing a short, simple complaint setting forth. Doesn't say you need to use any court form, right? Plaintiff's name, residence, plaintiff's defendant's name, nature of the amount. If the claim is based on a written instrument, a copy thereof must, right? So they went to the clerk of the court. Because first of all, again, just looking at what this is, either the clerk of the court has allowed errors and omissions to be made because there is no witness, there is no amount, they didn't tell you where to appear. We'll get into that shortly. Right? The clerk has got some explaining to do. Because these are the Supreme Court rules that we're reading now. These are the rules that came out of the Supreme Court of Illinois. So if they're not following these, they have a problem with the Supreme Court. Okay, based on a written instrument, yeah. Representative of corporations. No corporation may appear as claimant unless represented by counsel. Okay. Well, they have counsel that represents them when they go to court, so this could be a small claim based on that. When the amount of claim does not exceed the jurisdictional amount, the corporation may defend as defendant. So, through its officers. There you go. Form of summons. The small claim shall, yada yada. Got a couple of rules you got to file. Shall be in the form provided in Rule 101B. And we'll look at that shortly. Service by certified registered mail. Okay, that's how it was supposed to come, certified or registered mail. And I think they finally decided that the summons and complaint shall be mailed on restricted delivery basis when service is directed to a natural person. And I don't believe that they directed this to a natural person. They could have. As you can see, there are no date of service. I mean, this form here that they give you is incorrect. The point is, the form is incorrect compared to what the rules say. Okay. Unless the notice of defendant, see Rule 101B, provides otherwise, the defendant in a small claims must appear at time and place specified in the summons, and the case shall be tried on the day set for appearance unless otherwise ordered. Right? You're supposed to go to the day you went there. You're supposed to go to trial in small claims. If the defendant appears, he need not file an answer unless ordered to by the court. And when no answer is ordered, the allegations of the complaint will be considered denied, and all defenses may be proved as if they were specifically pleaded. Informal hearings. In all small claims, the court may, on its own motion or motion of any party, adjudicate, dispute, an informal hearing. At the informal hearing, the relevant evidence of the admissible to the court shall relax the rules of procedure and the rules of evidence. That the trial court may, by notice to defendant of the summons mentioned in Rule 101D, adopt a procedure best suited for local conditions and handling small claims. By the notice of the summons, the defendant should be given explicit directions on where to appear, whether he or she is to appear for trial on the day for appearance, or whether by filing a written appearance or giving appropriate notice to the plaintiff he will be excused from going to trial at that time. And I don't see where any of that comes in here. You are hereby summoned and required to appear. Right? There was nothing there. It's blank. So you're not required to appear. But it says you are hereby summoned and required to file an answer. But before you can file an answer, you have to appear, and the court determines if you need to file an answer. In the office of the clerk of the court. Well, why would you be doing the office of the clerk of the court unless they're handling the court under their rules? Interesting. No deposition shall be taken, no interrogatories, no motions, installment of payments, yeah, okay. And then service of process and proceedings to confirm a judgment by confession. All right, so we got confessed judgments that are enforced by the small claims court, because they're for a tort and they're just looking for property. They're not looking for damages for a particular value. They're looking for the property. Well, shit. What is a confession of judgment? No notice required. A confession of judgment is a modern day form of something, written authority given by a debtor for entry of a judgment against him or his or her in the event of a default. The promissory note itself gives authority to confess judgment against the defaulting debtor. Let's look at that. Look at this. Here's a promissory note. Now, I don't know if this is what they look like or not, but this is the only one I could find online. Let's say that it is. Lender's right. Upon default, lender may declare the unforgiven principal balance on this note immediately due without notice, and then I will pay the amount. Don't have to notice you. Confess judgment. Judgment by confession are controversial because of their summary nature and the lack of notice to the debtors. A creditor need only have an attorney sign a confession of judgment to obtain a judgment by confession. So all the creditor needs to do is take it to an attorney of record and say, look, they didn't do what they're supposed to. They confessed judge. Do what you need to do. Assuming the creditor has a right for the judgment and can do so without ever notifying the debtor. This lack of notice is why they are sometimes disfavored by the courts. However, the Illinois Supreme Court ameliorated the harshness of judgments by confession by enacting a rule governing how they may be challenged. This is where it gets good for us. Pay attention. By creating a vehicle for opening judgments by confession. Right? Somehow they have what they've done. So here's what I believe they've done. They've gone to small claims and they're trying to get. I closed the damn thing already. Confirmation of a confessed judgment. That's why there's no amount written up here. Get rid of this one. Don't need that one anymore. Alright, that's why there's no amount here. It's a confessed judgment. And now they're trying to get it confirmed. And so they've gone to small claims, opened up a case. Sorry about that. And so, by creating a vehicle for, I believe this number here is wrong. It's actually 276. We'll have to get to that in a minute. So, by creating the vehicle for opening judgment by confession, the confessed judgment's already been put in. They can get the confessed judgment just by having an attorney sign. Attorney sign a confession of judgment to obtain a judgment by confession. That's all it took. Didn't even have to go to court. An attorney signed it. Right? But now they want to get a confirmation, so they went and took it to small claims, opened up a case. We're trying to get this confirmed. Here we are. Well, now we can open the judgment by confession. The Illinois Supreme Court has ensured that debtors have access to court and due process is guaranteed. Consumer transactions are exempted. Now, I don't know if this is going to fit for us or not, but authority to enter a judgment by confession is found in the Code of Civil Procedures, in this right here, 735 ILCS 5/2-1301. It can only be used in transactions not considered consumer in nature. A consumer transaction is defined as sale, lease, assignment, loan, or other disposition of items of good, consumer services, or an intangible to an individual for primary, personal, family, or household purposes. Well, an intangible is a title to property. Because at the end of the day, it's all God's property. We can't own it anyways. It's just an idea that, hey, we're going to, take this square here and say you can have it, and here's a title, and, we'll defend you in this property for as long as you want to stay there. But if you ever leave it and abandon it, well, we can give it to somebody else. And we'll set that time for 6 months and, all this other stuff. It's all intangible. At the end of the day, it's not our property. It's God's property. So how to open, not vacate a judgment by confession in Illinois. This was some lawyer had put online, and I'm going to read it. I thought it was very good. My first experience in the confession of judgment clause. I can't believe I'm about to say this, but back when he was a young lawyer. When a client came frantically to his office, seems he had signed a document that contained one of those microscopic boilerplate confessions of confessed judgment provisions. Something like this. Upon default, lender may declare the unforgiven principal balance of this note immediately due without notice, and then I will pay the amount. You just confessed. Okay, he only signed for whatever reason, whatever. Okay, so I went in on an emergency motion to vacate the confession of judgment and unfreeze the account. Well, imagine my surprise when the judge told me there's no such thing as a motion to vacate a confession of judgment. Wait, what? How is that possible? Read the rule, counsel. Turns out he was referring to Supreme Court Rule 276, which provides the mechanism for opening a judgment by confession, not vacating it. We don't want to vacate it, we want to open it. Remember, opening's good, vacating's bad. The two key rules concerning confessions of judgment in Illinois are the aforementioned Supreme Court Rule 276 and Code Section, whatever it is, 1301. 1301 provides that any person for a debt bona fide due may confess judgment by himself or herself with attorney duly authorized without process. This is what they're doing. And that the application to the confessed judgment shall be made in the county in which the note or obligation was executed, or in the county in which one or more of the defendants resides, or in the county which is located any of the property, real or personal, owned by any one of the defendants. They had to put an application in someplace. Good to know. Where do you put applications in? Applications, I believe, go to probate. We learned that last week. Application or petition or complaint. Your three choices. And probate could be the small claims court, because they're not really handling money, right? That's other courts' things. They're handling titles to property. But confession of judgment provisions, consumer transactions are invalid and unenforceable. The code defines a consumer transaction, so here's one thing, right? An intangible. Again, I have to think about that more, but other than that, right? I never agreed to be put into a fucking trust. If that's what somebody thought, they're incorrect. Rule 276 provides that a motion to open a judgment by confession shall be, this is what you need to do now, shall be supported by an affidavit in the manner provided by Rule 199 for summary judgments, and shall be accompanied by a verified answer, which defendant proposes to file. The rule also states that if the motion to open the supporting affidavit discloses prima facie defense on the merits to all or part of the plaintiff's claim, the court shall set a motion for the hearing. The plaintiff, the party opposing your motion, may file a counter affidavit. Rule 276 continues, if at the hearing upon the motion it appears that the defendant, the moving party, has a defense in the merits of the whole of the part to the whole or part of the plaintiff's claim, that he has been diligent in presenting his motion to open the judgment, the court shall sustain the motion, and either as to whole of the judgment or to part thereof, to which the good defense has been shown, and the case shall thereafter proceed to trial upon the complaint, answer, and further pleadings, which are required or permitted. Can be opened if the moving party shows motion, affidavit, verified answer. The defendant can also assert counterclaims. Okay. Okay. In fact, all trial court does is determine whether the moving party's motion and affidavit says prima facie defense. Of course, means at first glance or on first appearance. The court conducts no inquiry into the disputable facts. Instead, the court accepts as true the facts asserted by the moving party in his affidavit. While the plaintiff may file counter affidavits in opposition to the motion of the party, the trial court may not try the merits of the case on the affidavits of the counterclaim because it would encroach on the right to trial by jury. A motion to open a confessed judgment is addressed in the sound discretion of the trial court and will not be overturned on review absent abuse or discretion. Logistical note: in Cook County, confession of judgment motions are heard in room 2503 of the Daly Center, the post-judgment law division room. Takeaways: Rule 276 provides clear and simple requirements for a motion to open, not vacate, open the JBC. The moving party must attach supporting affidavit, proposed response pleading. The movement must also show meritorious defense and diligence in bringing the motion. Once it's been opened, it proceeds like any other civil lawsuit. See, we're going to open the case, and now we're going to run it like a lawsuit. Right now, it's a confessed judgment against you. We're going to open it up and run it like a lawsuit. And that's where the frickin' instruments are that we're trying to find that say that you owe money or whatever it is. Right? If there's a complaint, that's where it is. I have to stress again, open the JCP because too much premature celebration. All it means is you can now defend a suit on its merits. We're not able to defend a suit on its merits right now because you're in this frickin' courtroom where they're not asking for money, but there's a confessed judgment against you, and you're not bringing up the fact that there's a problem with the confessed judgment. And we need to open this confessed judgment case by motion. So I got to do a little more work on this, but post-judgment and miscellaneous remedies. This is post-judgment and miscellaneous remedies section. You got a couple of judges here at the circuit court. It says they're in a different room, suite 1401, than what the guy said above, but nevertheless. The post-judgment and miscellaneous remedies section of the circuit court of Cook County is a section of the 1st Municipal District. That's interesting, the 1st Municipal District, because that's the same district in Wisconsin, in Milwaukee, Wisconsin, where they said in the 1st District is where the probate court would be, lowercase probate court, ecclesiastic style. In addition, they hear original actions such as replevin, detenue, confession of judgment, and revival. So that's in the Daly Center. If you're in Illinois, Cook County. Otherwise, we got a post-judgment and miscellaneous remedies we're trying to do, right? You're going to have to go to your clerk and say, hey, I believe that what we're looking at here, because there's no amount claimed, is a confessed judgment. I want to put a motion in to open it. And by the way, there is no witness on this. Apparently, supposed to be a summons. There's no witness. It's an error or an omission. You guys had better tighten it up back there. And what else was there on there? Post-judgment proceedings. Oh, okay. This is just that rule, right? Rule 276, opening of judgment by confession. And we pretty much already went through it. So, but if an order is entered opening the judgment, defendant may assert any counterclaim. See, now you can put your counterclaim in and say, that's my property and I want my securities back, including claims which have occurred subsequent to the entry of the original judgment. Oh, they're going to have a bad day. They're going to be crying for their mama. The original judgment stands as a security, right? Here we go. You guys put it in that they did you wrong. And an attorney signed off on it. Who brought fraud upon the court? And what did I... The main thing I had marked this thing up for, right? Because this is your standard mortgage paperwork. Changing laws now. We got applicable law, means controlling applicable federal, state, local statutes. Now, the thing is, there's all sorts of things about agreements when you read this thing, right? If you just go through, find one and look at it, for everything that says agreement. Well, for there to be an agreement, two parties had to agree. I'm trying to find, there's a couple in here that specifically says that, okay, first of all, here's where Bauer has abandoned property, and we saw before that's one of the things they're going to try to do, and people already know that, right? But according to the foreclosure laws, that would be incorrect. Property abandoned by borrower. Governing laws, serviceability, rules of construction. The security instrument shall be governed by federal and law jurisdiction the property is located. All rights and obligations contained in the security instrument are subject to any requirements and limitations of applicable law. Applicable law might explicitly or implicitly allow parties to agree to contract, or might be silent, but such silence is not construed to be prohibition against agreement by contract. Okay, so if we have a contract, well, both parties had to agree to something. So again, I don't know how to use all this yet, but the point is, right, that they've got to confess judgment against you already, and that they're saying that your warranty deed is a frickin', that whoever paid the $10 has the beneficial interest, and you gave up your beneficial interest on this piece of paper here. Where's the part about the borrower's right to reinstate? Transfer the property or beneficial interest in the borrower as used in this section. Interest in the property means any legal or beneficial interest in the property, including, right, so legal or equitable title, but not limited to those beneficial interests transferred in a bond for a deed, contract for deed, installments, sales, escrow agreement, transfer of title by borrower at a future date to a purchaser. Right, now who's the purchaser? The purchaser is the guy that spent the $10. The intent of this, of which is to transfer the title by the borrower at a future date to the purchaser. We were just supposed to be the trustee as far as they were concerned, and at some point we were going to transfer it to the purchaser, whoever paid the $10. Anyways, this allows you to give up the rest of your interest in the property, right? And that's what you've done. When you're all done, you've given up your interest. What you had was legal title and maybe some beneficial interest. Somebody else has the rest of the beneficial interest. And now you're going to give up your interest. And one thing here. So what is the loan? Means the debt evidenced by the note. Well, what did we find out earlier? Where was that? Debt may be extinguished by a creditor accepting a higher security. So as soon as they took that note and they made it pay to the order of by having it endorsed in the back, they took a higher security. There is no debt. So there is no debt evidenced by the note anymore. So you've taken care of the loan. See, this loan doesn't say anything about them lending you any money. Loan means a debt evidenced by the note. You promised to pay, right? All this is you giving away your property. This is a unilateral contract of gift or donation. You're going to gift them so much of your money. But they're going to take this and then they're going to endorse it and turn it into a check, basically, into another form of security. And so you've extinguished the debt. There is no debt anymore. A debt evidenced by a note may be extinguished by surrender of the note. When they surrender it to the bank, when whoever you gave this to, whoever this thing is made out to, is surrendered and they endorse the bank and give it to the bank, they surrendered it. Right? The note, the debt has been extinguished. So we need to figure out how to put these things into our motion or whatever our defenses are going to be. But understanding now that there is a confessed judgment because of this right here, without notice, boom, confessed judgment. And all they're trying to do in the court case is get that confessed judgment confirmed. And it's happening through small claims. And whatever you're doing in that courtroom is, some kind of theater. But the place you need to be is in small claims, or with the clerk of the court or whoever saying, or even in that case, putting in a motion, whatever it is, to open a confessed judgment, because you have a confessed judgment against you right now. So, okay. So I had to tell you, right? Like I said, I don't know what to do with it yet. Stuff I put together over the weekend, and I got lots more to go through. But there's a confessed judgment against you, and your warranty deed has been turned into an implied land trust. If you've gotten that much out of this video, I've done what I had intended to do to start with. And we'll just have to talk about the rest later. Alrighty, see ya.